Okay, everybody. I'd now like to introduce our next speaker, who is Mr. Brian Kirkpatrick. He's the founding shareholder of Kirkpatrick Law PC and a business attorney with technology focus. He also serves as of counsel of Mullin Law PC for matters involving technology and information security. His practice revolves around clients needing assistance in technology transactions, data privacy, cybersecurity, software compliance, and audits, and general counsel related to business matters. Brian was voted 2015 top technology attorney in Tarrant County by his peers as published in Fort Worth, Texas Magazine. Brian has published numerous articles and lectured nationally on legal topics such as software as a service, software licensing, contract negotiation, cybersecurity, and legal considerations when starting a business. He is also featured in radio news interviews as a conference panelist, a featured speaker, and is featured in an instructional video series about conducting negotiations. Before entering legal profession, Brian was a vice president commercial banker. Brian is a graduate of the Texas A&M University School of Law, where he was inducted into the National Order of Barristers. He also has Masters of Arts in Applied Economics from Southern Methodist University and a Bachelor's of Science Economics from Texas A&M University Commerce, where he was inducted into the Omicron Delta Epsilon International Economics Honor Society. With no further ado, Brian Kirkpatrick.
Thank you. All right, so I'm surprised so many people are here this late. I know why you're here. You're ready for me to finish so we can all get the prizes at the end. So I'm going to talk about mitigating security risk in vendor agreements. This is probably one of my favorite things to do. It's a big part of my practice. I kind of started out doing this in a weird way. I started out working at AT&T, and I was kind of thrown into the technology contracts area. And frankly, I had an interview. I BS'd my way through it, and looking back, I probably looked like a complete dope, trying to act like I knew what I was talking about. Turned out my boss, who was interviewing me, was a software negotiator for AT&T for over 30 years. And when I got into the job, I realized really quickly how much I didn't know. And man, I learned a lot in a very short period of time. I've negotiated deals up to $800 million for AT&T. And nowadays, when I do deals, they're $75,000, $100,000 deals because I have my own practice. And they're usually not that much at stake, but all the same principles and risk apply. And one of the things I tried to convey to my clients is that it doesn't matter if you're spending $1 million, $10 million, or $1 on software or services related to software, the same risks are there. If somebody has your data, they can do all kinds of stuff with it, or they could be breached. And so that's what we're talking about, is the third party breach. So when I look at risk, I think about, where does that risk lie? And I'm of the notion that our people are probably the highest risk, okay? But we have certain control, over the employees. At the beginning, we had a really good speaker talk about, how we can have more training around our employees and how to help them, like through phishing and then training after the phish. And I'm a firm believer that's the best stuff. To come in between the chair and the terminal is really where the main risk is. But sometimes we take that data outside the perimeter. It's going outside the company. And, it's out of our reach, but it's not out of our control. The way we can control is through the contracting. And, even though, it may be difficult or in some cases impossible to negotiate with some of the big vendors, if you're going to try to negotiate with Microsoft or Oracle, those are some tough players. Amazon is tough. But you can get traction if you know where the gives are. And also, kind of ask them to put, themselves in your shoes and if they would agree to something like that. And sometimes they're just not the right fit. And, even with big companies, if somebody is being unreasonable with their terms and conditions, if they're just unwilling to negotiate, my recommendation is don't do business with them. There are so many good companies out there to do business with that provide great service that you don't have to go with Amazon or a Microsoft. And so I would say, do an RFP. Look at your options because there are plenty of really good companies out there that are willing to negotiate and give you the protections that you need for your data. And so before I begin, though, I have to give the legal disclaimer. This is not legal advice, so don't go out and use my language on the slide and then have something blow up and come back and tell me I'm liable and send me a petition because I like that stuff. I like to try to be sued, I'll be happy to answer. But unfortunately, I have to tell you, if you need advice, you need to talk to a competent attorney of your choice. So I'll begin with common questions. And, a lot of my clients are in the security realm. And it's actually usually like one slot removed from a CISO, although a lot of the CISOs recommend me to their general counsel. I end up working with the general counsel of these companies. A lot of general counsel are really adept at whatever field they're in. So like if it's a bank, they're going to be really financially minded, but they might not know anything about technology. Or if it's a hospital, I've had hospital clients, man, they're really good at the HIPAA stuff, but when it comes to the technology around it, they really don't understand it. So I'll actually end up working with lawyers at companies. It's not all me all the time. I usually kind of work in tandem with them. And so one of the things, though, is that I'm kind of addressing this not from a general counsel presentation. So I understand there's not a lot of lawyers in here. And so, but I did kind of take this from a presentation. I give a 3-hour legal presentation for continuing legal education to lawyers. And I've pared this down to the essentials for the security professionals. And so when I talk with security professionals, they tell me, look, man, I'm not the lawyer. I'm going to pass this off to my lawyer, and you guys can talk about this. This isn't my problem. Okay. I go back with what CISOs always say is security is everybody's problem. Everybody has to think about it, and especially if you're in security, believe me, the fingers are going to start pointing at your organization before legals if something goes wrong. The next comment that I get is, look, we're short-staffed. We don't have budget. We're overworked already. We saw the CISO schedule earlier if you were in here, the day in the life of the CISO, the 4:30 a.m. to basically 2:30 a.m. Schedule of the CISO. So the question is, look, why should I listen to you? Why should I do legal's job? And I'm not advocating for that. But I will tell you that one of the main things that CISOs are really trying to do now is to break into that C-suite slot. They want to be on the same strategic level as the CIO, the CEO, the CFO, and the only way to do that is to show that you have a strategic mindset. And one of the ways to do that is to improve your vendor agreements. This is something that these guys in security are the ones that are looking at the vendor agreements. They're obviously the ones doing assessments, the technical assessments. So they're the ones that are in the best position to identify when there's technical risk. believe me, you don't want your lawyers trying to identify technical risk, especially if you're not working for a software company. And ultimately, you're in a really great spot to prevent some huge problems that, quite frankly, can be easily prevented. The next is, what's in it for me? Why do I need to do this? Why am I here, listening to you? And I'll tell you that to get into that C-suite, you have to build trust with your partners. And it doesn't matter if your ultimate goal is to be the CISO, or if you are a CISO, to be on the true C-suite with, the other top three, the general counsel and the CFO and CEO. But it will help you at any level build trust with your partners if you can identify risk in agreements and point that out to your supervisor, to your manager, to if you're working with legal. If legal doesn't have to ask you the questions, and maybe your legal doesn't even know what questions to ask, and maybe they feel important, they don't want to ask the questions, they'll just read the agreement themselves, and they usually attack the indemnity and the limitations of liability. But there's a lot of other risk in there that you guys can identify. And I think if you proactively bring this stuff up to your legal department, it really makes you look like a hero. And the lawyer, even if they don't act like a lot of them that I deal with that are general counsel, they have a lot of pride. They don't want to say, wow, good job, that was a good catch. They'll just take it back and maybe even pass it off as their own work that they caught all those risks. But in reality, they know, hey, if I need some help, I'm calling on this guy to help identify risk. Or if this guy sends me an agreement, tells me he's looked at it, I believe him because he's identified some good stuff. So I really think it helps build trust with your partners when you're reviewing these things. So I want to talk about 5 issues to review. And, although I called it top security issues, these are kind of the things that I start with. I think it depends on what industry you're in, maybe what the purpose of the agreement is that could make one of these not even in the top 5 and actually bring in one that doesn't even show up on this page. But I just want to preface that this is sort of generally the top 5 issues, but not necessarily in every situation. And so the first one was about the information security program. And so I want to make another distinction here that when I talk about an information security program, I'm not talking about the information security policy. Does anybody know the difference between that in here? One, the professor. Okay, so an information security policy is usually really general. And so if they say they're going to follow their information security policy, I say, let's see your information security policy. And quite frankly, and you can find lots of these online that are publicly available through universities. Universities apparently have to post their information security policies. And most of them fit on half the size of your computer screen when you pull it up. They're super general, super basic. It's half of a framework. And they have to basically say, this is our policy, we're going to secure your social security numbers, basically. Or not keep your social security numbers and issue you a student ID, that sort of thing. And all the information from your loan or your personal financial information that you may send in. And so what I asked for is, okay, great, you've got a policy. I want to actually see your information security program. Send it to me so I can have a look at it. And I actually represented a hospital, and there was a software company who was selling time tracking software to them, where nurses could come up and swipe their badge when they got in. They could swipe their badge when they got out, and it would clock all their time, so they didn't have to punch cards or sit down and log in stuff. It would just have all their information of who they are, and they could just kind of beep in and beep out, and that would track their time for them. And so I asked the vendor, I said, okay, well, send me your information security program. And they were like, wow, well, you know, we're going to have to get back to you on that. And so a week went by, and they got back to me on it, and they said, look, you know, we've been trying to figure this out, and we just got to come clean. We don't have one, and it's really embarrassing. But, you know, we don't have one. We don't know if maybe you can give us one. Well, I'm like, you're dealing with a hospital. You realize this, right? Under HIPAA, they have to have one. So I ended up drafting one and saying, you're going to implement this security program if you want to do business with this hospital. You have to. And so another thing is that if you get the information security program, here's something that I see almost every single time. First of all, there is no information security policy attached to the agreement. Second of all, there definitely isn't a security program attached to the agreement. And then even if they send it to you, that doesn't mean that it's part of the agreement. And so they say, yeah, this is what we do. But try to find that in the agreement that they sent you. It's not going to say that we're going to follow our information security program. And so I recommend actually adding a warranty to that, or at least alerting your attorney to add some warranty language. And here's some basic language. And basically what it says is, we're going to do what we told you that we do after the fact, even though we didn't initially put this in our agreement. Here, we're sending this PDF to you. Now we're going to attach it, but then, you know, you literally have to go in and say, okay, I'm calling this Exhibit A or whatever exhibit you want. And put some language in there that forces them to actually comply with that. Otherwise, them telling you that this is what we do is definitely not enough. Okay, so the next one is security standards. All the time on agreements, I see very vague or ambiguous statements related to security standards. And this will be things like, we will agree to adhere to the security standards or the industry standard. We'll agree to adhere to the industry standard. The problem is that you look at that and you're like, wow, that's good. You know, they're going to adhere to the industry standard. But you don't realize that their industry is not your industry. And also, we don't know what the industry standard is. Maybe it's a third industry standard. And when it's vague like that, guess what? That's the kind of crap that goes to court. Because, you know, if something happens, you say, well, you said you're going to adhere to the industry standard. And you know what? If it doesn't fit that it's either industry standard, they'll say, oh, we meant this third industry standard. You know, maybe it was, we were thinking we were under the NIST standard or the ISO standard or Corbett standard or whatever standard we decide we want to be under at this time. So that vague language actually helps out the vendor, doesn't help out you. And so you have to determine whose standards matter. In the case of a hospital, believe me, it's going to be the hospital industry standard. It has to be. But if it's, you know, a manufacturer and a software company, then it really is negotiable. Like, what makes sense? Maybe you want to be under the software standard because maybe that's a higher standard. Maybe you want to be under the manufacturing standard. Maybe you want to have, you know, kind of a comparison of both and see which ones matter. And you could do that, you know, during the initial stages when you're contracting with them. And then you need to look at the agreement and make sure that those standards actually apply. So here's some questions for this one that I like to ask. And I just like to ask them, what standard do you use to protect your own information? You know, a lot of times how they protect their own information may be different than how they protect your information. And a lot of times that's not in a security section. That might be in a confidential information section. And it gets kind of tricky because that language is used in confidential information. But, you know, they say that they'll agree to protect your confidential information just like they protect their confidential information. Unfortunately, the two confidential informations are completely different. And your confidential information may be way more valuable than theirs. Theirs might be, as important as sales reports, like pricing information. A lot of these companies use open source code to make their solution. So really, even the code isn't like big IP. I mean, it's based on code that's already out there. And so, also determine, what your industry standard is, so and that way you can kind of go through and look through the agreement and see if you can find your standard listed at all. And so that's what I mean by the last one, is if you know what standard your company has to adhere to, then just do it literally a control find and try to find it in there, and I bet you don't, because this is going to generally say the industry standard. And then what I would say is you add that name in, the manufacturing industry standard or whatever your type company is. Just put that right in front of the word industry, or maybe recommend that to your legal counsel. So the language that I use is I actually make them state that they're going to perform in accordance with that standard, and then kind of generally, and then I'll add like another sentence in there that'll say specifically they're going to comply with, HIPAA or GLBA or whatever. The HIPAA and GLBA are usually the most strict, because that's either your healthcare or your financial data. Okay, so a lot of y'all were in here when we were talking about data breach insurance. And I think that presentation made it really clear that it's not clear how good data breach insurance is. One of the things that I like about data breach insurance is that it's really hard to get. And so now if an insurer is going to write a policy, they're actually going to have usually some due diligence to check to see what kind of controls have been put in place for that. And so it's sort of a second thing to look at. And then also, they talked about indemnity, and that's a big deal. So a lot of times in an agreement, it'll talk about, we're going to indemnify you for these types of claims. So it's nice to have this in here. The problem is, and it wasn't on the presentation before, is that you really have to pay attention to the limitation of damages section, or otherwise known as limitations of liability, because what that'll do is just negate all of this. They'll say that the limitation of damages is like limited to the last 3 months of fees paid for the service or the software. And so you can have $1 billion of data breach insurance, but if your limitation to damages is 3 months of fees paid and you were paying $15 a month, it's not worth anything. So all of those things have to be analyzed in tandem. Where I would say that security professionals can really come in is looking at the coverage types. You know more than anybody what kind of risk your company has, and that's the thing that makes all of those actuarial tables and charts really crazy, is that every industry is completely different, and they have completely different risk associated with them. And so taking like averages across the globe is crazy. Like we heard somebody say the average cost of a record is $8. Another one, is $200 or $400. It really depends on what the industry is, what kind of data you have. Are you taking credit cards from everybody? And also your risk calculations come into that as well. How much security you've had over a period of time, and what kind of experiences you've encountered. But what I like to do with the data breach insurance piece is, first of all, do they say that they have it? Do you even need it? Are you really putting data on their systems, and how are they getting the data? I would rather know that they're encrypting the data in transit and encrypting the data at rest than to know that they've insured it, because even if there's a breach of encrypted data, a lot of times that doesn't even trigger, in a lot of states, it won't even trigger data breach notification rules. So I would be more comfortable with encryption across the board than data breach insurance. But one thing I like to know is, do they have it? And if they do have it, I like to look at the policy and see if it even covers what is of interest to me. And another thing is that just because they say they have it, doesn't mean that you're a named beneficiary on it. And so make sure you get that certificate of insurance with your business name on it, because them having just general data breach insurance doesn't mean that you're going to be one of the beneficiaries after they pay out everybody else. You may not have any. So it can have this really beautiful long section of all the coverages, the E&O, and the cool kidnapping insurance and all that stuff. But unfortunately, if you're not named, chances are that's just a bunch of text. So one of the things that I do with this basic language is have that they will have this insurance, but I'll tell you that there's a trick here in this language, and that it's that they maintain that insurance after the agreement. So a lot of times when you terminate agreement, they say, hey, we're terminating all clauses. Well, within contracts, sometimes there's a couple of ways you can make things survive. In the clause itself, you can have, through each clause, you can have it say that this clause will survive, and then 5 or 6 clauses later, this clause will survive. Sometimes there's a survivability section, and it goes through and lists all the sections that will survive. And so I like to make insurance survive past the termination of the agreement, because they could be holding on to your data after the fact. And so that gives you time to make sure that it's cleaned up. Also, some additional language that I might throw in there is just, to get evidence that they've destroyed the data, any residual data, returned everything to you, get them to sign off on that to make them liable for that as well. And so you have those requirements in addition to this. So this basic language, the trick here is to get it to go after the agreement, which makes it survive the termination of the agreement. Okay, so the next issue that I look for are security audits. And what's interesting, the last firm I worked for, a big portion of our practice was software audits, and it was kind of from the other side. I was on the defense side, and I still do that to some extent with my current practice. But security audits are really interesting, and you can have audit language in agreements. And so I will tell you that if you're getting any kind of big software, and what I mean by big software, big name brand software. So if you have Adobe software or Microsoft or Autodesk, if you're engineers, that kind of stuff. And when you're just clicking through, I accept. Well, you accepted, it's in all of them, you accepted audit language in there that says that we can come and audit your books, records, and systems, basically without any limitation. So that literally means that you've agreed that they can walk through your front door of your business and start sitting down at terminals and going through your system. And that's really bad. But you know what? You can do that too with your vendors. You can ask for audits. Now, when you ask for it, because it's definitely not going to be in there as an option at all, but when you ask for it, you can structure it in a way to where it's reasonable and acceptable to them. And so just a few ways that you can do this. If you have the leverage, if you've got the muscle, the upper hand in the negotiation, then what you go for is number one. You say that we can physically enter the premises and start auditing directly. And then what they're going to come back with, if they really want the business, is they're going to say, well, they're going to put time constraints on there, like you have to do it during normal business hours, Monday through Friday with notice. Maybe you have to give us a 10-day notice or something like that. Let them come up with the limitations and stuff. But basically what you want to try to get is the ability to audit, because they're holding your information. So you need to be able to go in and check that they're actually doing what they say they're going to do. Another way is to get a third party to do this. So you can have, you can have like an Ernst & Young or KPMG or these guys go in and provide a third party attestation that the controls are in place, as they say. And usually that's going to be with a larger company. But if you're with a big company and your vendor is also a big company, this is something that's actually pretty normal, and I don't think anybody would even balk at this. And then if you do deal with a company like an Amazon or somebody where you have very little leverage, one of the things that you can still ask for is just to get a signed self-attestation. Regardless of the size company, this is kind of the weakest. But again, they're signing off saying that they have the control. So it's just another thing. It's, you want to have them say, represent in the agreement, this is what we do. You want to have them warrant, provide that warranty that, okay, here's what we do. And then you want to have them sign off that, yeah, we actually did it after the fact. And so it just gives you more power in a lawsuit to go after them if you have to. Yeah. Uh-huh. It's negotiable. Yeah. And so in the number two, so number one is you've got leverage. Number three is you don't have any leverage really. And then number two is kind of on balance. Usually it's like, maybe, just to say, like, it might be like an AT&T IBM arrangement. They're both big dogs, big players. IBM can say, look, dude, we're not providing that. And AT&T can say, well, we need it. And they'll say, look, we'll provide this third party because we don't want to let you in looking at our systems. So we'll get KPMG to come in and do it. And we can all trust KPMG or, Ernst & Young or some third party. So usually that's what happens. It's almost like an arbitration kind of agreement, really, is that you're agreeing that some third party will resolve this issue of your compliance. Okay, so basic language for this. Usually you want to get these audits or attestations annually. I went with the number two just because it's kind of more normal to have a third party do it, because really nobody wants to let you into their office. And I wouldn't recommend it. If I was your counsel, I would say, no, nobody's coming into your office. Do not click accept on that. And that's one thing I would, if there was anything in an agreement that I would try to change, even if you're like, man, we're dealing with Microsoft here, I would try to just cut out the audit section or at least make it reasonable. That is so important, not to let one of these companies come in to your books and records. I mean, that's literally what it says, books and records. That's everything. Any questions about that language? Okay, so next is information security warranty. This actually warrants that that there's specific controls in place. And so this is really a cool topic, because you can look at those controls that they provided you in the information security program, find out which ones are important to you, and then ask for a warranty on those controls. And that they would actually, protect you against the loss. So, in this situation, a lot of times, you get that information security program, and they say, you know, yes, we'll adhere to this, but it doesn't have any warranty to that. And so then it gets really technical with respect to, you know, what's the difference between a representation, a warranty, and the difference between those is what kind of damages can you collect off of them. And a warranty is going to be stronger than just a representation. And so I would find those specific controls, because sometimes an information security program can be really long. I've seen them probably as much as 30 pages long that really go into a lot of detail of their controls. But I would find those that are really important to me, maybe set a warranty on 2 or 3 of them, just to strengthen the agreement. Or, you know, from your position, same thing, I would identify those and then talk to your internal counsel and say, hey, yeah, I know they gave us this security information program that we had to ask for 3 weeks to get. And I think that these 3 controls are really important. You know, why don't you ask for a warranty on these for us? So it'll help strengthen our agreement. And so the reason for that is if they don't have that warranty in there, what they're going to say is they disclaim all warranties. Every agreement has this. I don't care where you are. You're Best Buy and you know, buy a refrigerator. It's got a disclaim warranty section in it. This is like standard language here. And so to make sure that you have that warranty, you have to go in and add it. And so that's what I'm getting at. And so here's, you know, 4 examples of warranties that I would ask for related to a security information program. Is that number 1, you're going to comply with it. Number 2, that you're going to perform in accordance with it. That's actually different. And that you're going to conduct the security audits, or you're going to have a third party conduct them. And that you're also going to maintain the appropriate insurance coverage. And so, again, all of that stuff is negotiable, but I would much rather have that as a warranty than not, because otherwise they will take it out altogether. And as a matter of fact, you know, if you don't have that warranty from above, they will even say that, look, we didn't warranty data breach. I mean, it's kind of normal. I mean, they will not warranty non-infringement even. That gets off topic, but there's a lot of stuff that is not in a warranty that should be. And this is, you know, this presentation is limited to the security pieces, but if you critically look at these things, there's a lot of missing parts, and that's what makes contracts fun to me. Is that when you look at these things, you know, you have to understand what's important to you, and if you don't, you know, somebody says, well, hey, look, this is just a simple agreement. You know, this is only a 2-page agreement. You know, they sent this to us. The problem is not what's on that paper. The problem is what's not on that paper, and that's where having a skilled attorney and a skilled security staff can really help say, man, you're missing the security program, which should be longer than 2 pages. So if I'm looking at a 2-page agreement, we got a big problem. So that's really the issue. Is, you know, a lot of my clients, they think the shorter the agreement, the easier it's going to be, and it's actually the opposite. So some language that you can use here is that they're going to warrant that they're going to abide by the security program, just like we had above. And then, you know, kind of going through those 4, but this is more of a sentence format. And then, although I said, like in this slide before about the standard in number 2, here in the language, I would actually write out, you know, what that standard is, because we talked about how important knowing what standard we're talking about is. And I'll tell you, as simple as this sounds, it's never in the agreements this way, ever. I've never seen it once. And that they're going to maintain the insurance that they said that they would. And then I just went ahead and put in here that it's going to be a third-party audit, because that's most likely what will happen. So for a summary of this, every industry has different risk. So again, this may, you know, some of this may apply to you, some of this may not. But I will tell you that vendor agreements are extremely important because everybody keeps mentioning Target and Home Depot and all that. And I don't know if everybody here, there's some students and stuff in here that realize, but that's how these companies were hacked. Target wasn't hacked. The HVAC supplier was hacked, which gave them an in to try direct into Target's data. So if your third-party vendor gets hacked, that's a big problem. And really, some of the bigger companies you don't have to worry about so much. It's some of the smaller companies. You can get really good deals and they're very negotiable with you, but you have to make sure that they're actually following through on these protections. Another thing is if you can form a tight alliance with your legal department. I'll tell you, legal has, generally pretty good power in a company. Almost everything has to be run through legal. A lot of stuff gets thrown over the wall to legal, just like it gets thrown over the wall to security. And, they're just like, hey, look at this agreement, or, oh, hey, Brian, one of our BPs signed this agreement last year without approval, and, how do we get out of this? Unfortunately, that happens a lot too. It's, legal wasn't involved in that agreement, but somebody just went ahead and, committed the company to this. So now we're looking for ways to get out of the agreement. So having that tight alliance with legal to where you feel comfortable sharing information, and then they feel like they've got a good trust relationship with you, that you're looking out for the company too, I think makes you kind of strong when you're both together. And then, when you're going to the CIO asking for money, to have legal support, I think is really good support to have. It makes your argument for budget better. And also, I think from a CISO level, it kind of brings that trust level up to where it's like, man, we do need this guy either in the C-suite or on the board of directors. And that is sort of from a policy standpoint, that's where the CISOs are trying to get to the end, is to be either really on the board of directors. Security right now is not really part of the board of directors, which is really scary. And so that's sort of my last deal, is that this, is down in the weeds as this sounds, just identifying these things. You don't have to fix them, just identify them, bring them up to legal, or even your management or procurement or whoever's in charge of it. It will just give you a lot more trust and a lot more strength when you need something back from them. So thanks a lot. Anybody have any questions?
If you have an employee who clicks through on an end-user agreement, what does that potentially open you up to?
It completely screws you. So what I do in my agreements, no, seriously, it does. It is, that agreement can wipe out what you've done. So let's say you hire me and I come in and negotiate a master services agreement. It takes a year. It's with a big company. And we get everything, straightened out. We finally have a deal that both parties can live with. It's going to be a great solution. And then they turn around and then they deploy the system, and your users go in and they all click I accept because they're logging in for the first time. And it's like, oh, well, you have to accept these terms and conditions. That can obliterate the master agreement. And a lot of times it even says that, the terms that you're agreeing to supersede any prior agreements. So that's another thing. It's not really a security thing, but in my agreements, and I'll tell you, it's very rare. I don't see many attorneys putting these in agreements, is I actually put a clause in there that says no click-through agreements or click-wrap agreements will supersede this agreement. And so no end user has the authority to bind the company. It has to be at this level or by this department in writing by both parties, signed, the click-throughs don't count. That's the way I would address that. If you don't have that and there's a click-through, you're screwed. Yeah. Yeah, so I would say you can always negotiate, and it depends on your leverage, right? And sometimes there's things in there that'll say like that you can't, but that's really rare. For the most part, you can always come back and renegotiate. You just tell them, look, things changed. You can even make up some, say we had a situation in our, one of our business units, and legal's coming down on us now and making us come back and renegotiate this particular term. We're proposing this amendment that changes these 5 clauses. And if you've got enough leverage, you can say, look, we're not trying to, change pricing or anything here, because usually it comes down to money. And if you're like, look, we're paying the same money, but these controls are in place for a reason, or, hey, we got a new CISO, he's coming down hard on us. He said that if you don't want to agree to it, then we'll just open it up for an RFP, and we'll be happy to include you in that RFP. I can't open up an RFP. Usually there's termination language in there. That'll say that if you have the right legal counsel, you can find ways to terminate, even if it says that it's not, you can't terminate. You can find reason, because there's always a termination for cause. Go dig up some cause. And if you don't have it, you can still threaten it. And it just depends on the leverage. And if you let, your professional negotiators do that, if you've got counsel that are trained in that, then they'll do it. That's, the big law firms and the big like Amazon type attorneys, I mean, they're trained in that. They're used to being bullies, and they learn tactics like that to get things amended. And then sometimes things really do change, and the best thing to do is just to have a termination for convenience section in there that allows you to terminate for any reason at any time. That's not always easy to get, especially with bigger suppliers, but it's something that I always shoot for, or at least a more reasonable termination. And then you can think about what those kind of things could be, industry standard changes. And if you're by the, if you say that our standards change, then we have to go back and renegotiate the agreement to adhere to those standards, then that's the way it'll be. And you get those kind of notices. No, just like the insurance lady was saying that, only the lawyers read these things. Is that a lot of these agreements will have language like that in there already, but it's vague, so you just have to clarify it. Yeah. What else? Ask me something hard. Let's argue. Okay, cool. Let's go get some prizes.